Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the Indian family laws. Maintenance under Islamic law holds great importance when it comes to questions asked in competitive exams. Let us start off by understanding a little about maintenance itself. In Arabic, the word maintenance is equal to the word nafaqa, which literally means an amount spent by a person over his family. Maintenance includes all those things which are essential to lead a life, such as food, clothing, and residence. They conclude this by relying on the concept of kinship. A person is duty bound to provide the basic necessities of life to his family members. The concept of maintenance was introduced to provide support to those people who are not capable of maintaining themselves. Under Muslim law, maintenance includes food, clothing, and lodging. Under Muslim law, the following persons are entitled to maintenance: the wife, young children, the necessitous parents, other necessitous relatives within the prohibited degrees. Firstly, the maintenance of wife. Under Muslim law, the wife's right to be maintained by her husband is absolute. A Muslim husband is bound to maintain his wife of a valid marriage even if there is no agreement in this regard. Wife's right of maintenance is a debt against the husband. It is an independent right. A Muslim husband is not bound to maintain the wife of a void or an irregular marriage, except when the marriage is irregular for want of witnesses. The husband's obligation to maintain his wife exists only so long as the wife remains faithful and obeys all his reasonable orders, that is, discharge her own matrimonial duties. However, if the consummation is not possible due to the wife's ill health or old age, she is not guilty of transgressing her matrimonial obligations towards her husband and may still lawfully claim maintenance from the husband. The wife could also claim future maintenance on account to prenuptial agreement vis-a-vis sustainable maintenance in the event of ill treatment. The right of the wife to maintain exists in spite of the fact that she can maintain herself out of her own property. The maintenance of wife has been provided for under the Muslim Personal Law, Section 125 of the Criminal Procedure Code, the Muslim Women Protection of Rights on Divorce Act of 1986, and according to the Muslim Personal Law, a divorced wife can claim maintenance from the former husband only for the period during which she is observing her iddat. The duration of iddat on divorce is 3 menstrual periods, or if pregnant, till the delivery of the child. The former husband's liability extends only up to the period of iddat and not beyond that. Section 125 of the Criminal Procedure Code 1973. The term wife includes a divorced wife. Section 125 is applicable also to a divorced Muslim wife. Section 127 Clause 3 provides that the order of maintenance in favor of a divorced wife shall be cancelled and such woman shall not be entitled to maintenance under the following circumstances: where the divorced woman has remarried, where such woman has received the whole sum due to her on divorce under any customary or other personal law, and where the woman, after obtaining a divorce from her husband, has voluntarily surrendered the right to maintenance. And lastly, it has been provided for under the Muslim Women Protection of Rights on Divorce Act of 1986. Muslim personal law imposes a limited obligation on the husband to maintain his wife after divorce, since it imposes the liability to maintain the divorced wife only during the period of iddat and not thereafter. The Muslim Women Protection of Rights on Divorce Act of 1986 was passed to protect the rights of Muslim women who have been divorced by or have obtained a divorce from their husbands. Maintenance during iddat. The divorced woman is entitled to a reasonable and fair amount of maintenance for herself during the iddat period from her former husband. However, maintenance after iddat, the divorced woman who remains unmarried after iddat and is unable to maintain herself is entitled to get maintenance from her such relatives who would inherit her properties upon her death. In the absence of any such relatives, or where they have no sufficient means, then ultimately the liability to maintain her is cast upon the Waqf board of which state in which she resides. This act has now made the operation of section 125 to 128 of the Criminal Procedure Code optional in respect of a Muslim woman. Maintenance of children. Under Muslim law, a father is responsible for maintaining his child with certain conditions attached to it. The father is bound to maintain his son till he attains majority and the daughter till she gets married. A father is also liable to maintain his major son if he is a lunatic or mentally or physically disabled and not in a condition to maintain himself. The father is not bound to maintain children if they refuse to live with him without any reasonable cause. The father has no obligation to maintain his illegitimate child under Muslim law, but is liable under section 125 of the Criminal Procedure Code. The mother's obligation to maintain her child arises when the child is illegitimate and the husband has refused to maintain the child. The mother has very little obligations to maintain her child only in the Hanafi school. There is a provision which follows that if her husband is not financially well off, whereas the wife can afford a comfortable living, then she has the liability to maintain her child. But she can still recover the money from her husband as per the law whenever he is in a condition to pay it. The maintenance of parents. Maintenance of parents is due to a relationship within the prohibited degrees in proportion to inheritance. It is obligatory upon a man to provide maintenance for his father, mother, and grandfather and grandmother if they happen to be in the circumstances necessitating it, except his wife, children, parents, grandchildren and grandparents. A man is not obligated to maintain other relations belonging to other religions. The fact that they may belong to other different religions makes no difference. The parents have the next position in the right of maintenance after the children. The liability to maintain parents rests only on the children and is not shared by anyone else. As between the parents, the mother is entitled to preference over the father. When it comes to the maintenance of parents, there are three views in the proportion of the liability. Firstly, that the liability is in proportion to the shares of inheritance, or if there is a considerable difference in the means, the maintenance is to be provided in the proportion to the means, or that the duty to support is equal and that the right is equally incumbent upon a son and a daughter. According to the Shia law, the right of two parents is equal. So also the right of the parents and children are equal. Maintenance must in each case be divided equally, but the parents are preferred to grandparents. I hope this video was helpful in providing a simple and clear understanding of maintenance under Islamic law. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.